We're back live.
Yes, we should be live now.
All right, thank you. Well, good evening, everyone. I appreciate it. Everyone joining us here. Hold on, I have the video on in YouTube in the background, so let me turn that off. Okay, well, thank you everyone for joining us. It's great to see you all. I hope everyone is having a really awesome summer so far, and I appreciate that we have such tremendous attendance for a July meeting. That's great. So Judge DiLeonardo, I just wanted to share that I did take the roll call, and we do have a quorum. So I think we can go ahead and get started when you're ready.
All right. Well, good evening, everybody. Again, it is good to see you, and I share on that, hoping you're having a good summer so far. I guess our first item will be the approval of the minutes from the May 9th, 2023 meeting. You have received that, should have received that distributed earlier. Is there any motion to accept the minutes?
I'll move to accept the minutes.
Or is there a second?
Second.
All right, any discussion on the minutes? Seeing none, all in favor, say aye. Or raise your hand, it's fine. All right, anyone opposed? None. Okay, well, adopted the meeting. So with that, we'll get to the guidelines subcommittee report, and Judge Avery, I will hand that to you.
All right, good evening, everyone. The guidelines subcommittee met on June 21st of this year. It was a lunchtime meeting. We reviewed a number of classifications for new offenses, and I'm going to let staff present the substance of those discussions, and then we can talk about the issues if necessary.
Great, thank you, Judge Avery. I'm going to start our subcommittee presentation with agenda item 4A, which is the proposed classification of new and revised offenses from the 2023 legislative session. And I want to begin, as I do each year, just to give you a little bit of background. I know we have a couple new commissioners since we've last completed this process. So just give you a little background. This is an annual job that the commission undertakes to review, new penalties or revised penalties from the most recent legislative session, and to consider how those criminal penalties will fit within the Maryland sentencing guidelines. Now, the task of classifying the new or revised offenses is designated to the guidelines subcommittee, and then those classifications are presented to the full commission for review. In preparation for this task, the staff reviews all legislation from the most recent session and prepares a memorandum that identifies any new or revised criminal offenses that carry a maximum penalty of greater than 1 year of incarceration. Now, the memorandum focuses on penalties of 1 year or greater because by rule, the commission does not require classification of offenses that carry a maximum penalty of 1 year or less. Rather, we assign those offenses automatically as seriousness category 7. So with that introduction, I will now refer you to the memorandum that was distributed that's labeled proposed classifications of new or revised offenses. It is a 23-page document divided into 4 sections. First, you have the new offenses with action recommended. Then you have changes to existing offenses with action recommended. Then there's new offenses with no action recommended, and finally changes to existing offenses with no action recommended. And for your reference, we also provided a supporting document that was labeled Combined File of Legislation with New and Revised Offenses. This is a PDF that combines all the legislation that is reviewed in this memorandum, and the bills appear in the order that they are listed in the proposed classification memorandum. Based on the previously established protocol, the subcommittee offers seriousness category recommendations by examining currently classified offenses that are comparable based on the following: the type of offense, meaning whether they're a person, drug, or property offense, the statutory maximum penalty, the misdemeanor felony classification, and when possible, the nature of the offense itself. So for each new or amended offense, the memorandum will present staff-identified comparables at the bottom of each page, or sometimes on the subsequent page. So starting on page 1 of the memorandum, let's begin with the new offenses for 2023. On page 1, we are looking at chapters 698, 699 in reference to House Bill 745, Senate Bill 340. This is titled the Anti-Swatting Act of 2023, and it creates a new offense prohibiting a person from making a report of an emergency that the person knows to be false to a governmental emergency report recipient with reckless disregard of causing bodily harm to an individual as a direct result of a response to the report. The person who violates this prohibition is guilty of a misdemeanor and is punishable by imprisonment for up to 3 years or a fine of $2,000. The bill also prohibits a person from making a false report of an emergency or alleging the commission of a crime resulting in a response from law enforcement and serious physical injury to a person or the death of a person as a proximate result of lawful conduct arising out of the response. Under these circumstances, a violator is guilty of a felony, which is punishable by up to 10 years of imprisonment and a $20,000 maximum fine. The comparables are provided on page 2. The subcommittee recommends classifying the 3-year misdemeanor as a person offense as a seriousness category 7. Further, the subcommittee recommends classifying the 10-year felony as a person offense with a seriousness category of 5. And I present those as the recommendations of the subcommittee and call to see if there's any discussion.
Also, I think that was a unanimous
Yes, that is correct. Thank you for sharing that.
recommendation. Yeah.
So are you asking to take these individually or collectively as one?
So for the beginning ones, Judge Dianiaro, yes, we're asking to take them individually. Luckily, it's only a few that we have to take individually. And then the majority of the memorandum refers to bills where we're not calling for any specific action. So we can discuss any that the commission would like to, but we won't have to require it. Okay. So for this one, yes, calling for an individual vote on those classifications as noted on page 1.
All right, so with that, is there a motion to accept the classifications of new offenses as the false statements?
I move that we accept the recommendation of the committee to use those seriousness categories for the 2 offenses just discussed.
Thank you. Is there a second?
Second.
All right, any discussion about the classification? Being no discussion, all those in favor signify by raising your hand. Anyone opposed? We have, okay, very well. The motion is passed.
Great. Moving on to page 3, we will continue with chapter 546. This is reference to Senate Bill 470. Senate Bill 470 creates a local land trust revolving loan program and prohibits a person from knowingly making or causing to be made any false statement or report, including any understatement or overstatement of financial condition for a new loan or affecting a loan already made under certain circumstances. A person who violates this prohibition is guilty of misdemeanor, punishable by imprisonment not exceeding 5 years and a fine not exceeding $50,000 or both. Based on the comparables, which are listed for this offense on page 4, the subcommittee recommends classifying this false statement offense as a property offense with a seriousness category of 7. Any discussion on this particular classification?
Okay, seeing none, is there a motion to accept that recommendation?
Motion to accept.
Right, any second? Mr. Fitzy, you wish to second or you wish to discuss the matter?
Second, I'm sorry.
Okay, any further discussion? All right, seeing none, all those in favor signify by raising your hand. All right, anyone opposed? All right, that recommendation carries.
Great. Okay, we'll now move on to the review of changes to existing offenses. This is starting on page 5, chapter 651, with reference to House Bill 824. House Bill 824 alters criminal law article section 4-203C2I and 4-203C2II to increase from 3 years to 5 years the maximum incarceration penalty that may be imposed for a violation of the prohibition against wearing, carrying, or transporting a handgun when the person has no prior convictions under 4-203 or 4-204 or 4-101 or 4-102. Based on the comparables identified on page 6, the subcommittee recommends classifying these 5-year misdemeanors as person offenses and changing the seriousness category from 7 to 6 to reflect the increased penalty. So that is the recommendation of the subcommittee, and I open it up to any discussion.
I move the committee's suggested motion of modifying this particular categories.
All right, thank you, Senator. Any other second for that?
I'll second.
All right, thank you. Any further discussion?
I just have one quick question.
Yes.
I see this is actually for Judge Avery maybe or anyone on the subcommittee. I see why it's a category 6 based on the punishment, but I also wanted, or the maximum punishment. I also wanted to know if you all had any discussions around the fine, or if that is or how that is. I just don't have the history of how that is incorporated with respect to categorization. If maybe Dr. Soleil or anyone could just give me a little bit of background on how the two are kind of reviewed.
Well, I will just say that we did not discuss the fine.
That's correct. The fine is this, Delegate Barlow, we have not traditionally focused on the fine unless there's some instance that, it's always been the primary focus has been on the statutory maximum penalty. We're looking for comparables, primarily the same type of offense, person, drug, or property that has the same statutory maximum penalty, and not focusing on if there's any differentiation in the fines.
Okay, thank you.
All right, with that, is there a motion to accept these recommendations?
I think we had a
Motion was
motion.
already
Yeah, we
made.
I think we did it.
We already did that. We
Oh,
need
we're
to
now
vote.
asking for the vote.
Yeah.
I got sidetracked. I apologize. All those in favor, raise your hand. All right, anyone opposed? All right, the motion carries.
Okay, great. So we can move on to page 7. We'll continue with chapter 797, which is in reference to Senate Bill 54. Senate Bill 54 repeals the crime of unnatural or perverted sexual practice. The subcommittee recommends removal of this offense from the sentencing guidelines offense table. Any discussion?
All right, can I have a motion on this?
So moved.
All right, a second.
Second.
You. Any further discussion? All those in favor of removing that signify by raising your hand. Thank you. Anyone opposed? None. Okay, motion carries. Dr. Soleil.
All right, great. So that was all the ones that we need to go through on an individual basis. So for the remainder of the document, pages 8 through 23, there is no recommended action by the subcommittee. And let me just explain that. The subcommittee recommends no action on the remaining offenses for a few reasons. First, for the legislation that's listed on pages 8 through 12 of the memorandum, those are new offenses that have a maximum penalty of 1 year or less. And as I already explained, the commission has a longstanding policy that unless the commission chooses to do something otherwise, we will automatically assign a seriousness category of 7 for any offense that carries a maximum penalty of 1 year or less. For the legislation that's noted on pages 13 through 23, which offers changes to existing offenses, the subcommittee recommends no action because for the most part, the changes are, there's no change to the criminal penalty structure. And therefore the staff and the subcommittee recommends that no action is needed because it's while they are sometimes substantive changes, they are not changing the maximum penalty, and so it doesn't seem like there's a necessary action from the Sentencing Commission. Of course, we are happy to review any of the specific legislation or offenses that are noted in the remainder of the document that have no designated action, but I'll defer to the commission decide if any offense-specific or legislation-specific review is necessary.
All right, well, there being none, Dr. Saleh, pass you to the next item.
Okay, great. So for the next item, I'm going to turn us over to Mark Mills, who is our graduate research assistant on staff. And Mark is going to present miscellaneous previously unclassified offenses. Again, for those who are new to the commission, from time to time, we become aware, usually through interaction with those who apply the guidelines, that there is an offense that hasn't been classified previously for whatever reason. And so this particular memorandum relates to a few that were identified recently. So I'll turn it over to Mark to explain those.
Thank you, Dave. Good evening, everyone. I would direct everyone's attention to the memorandum labeled Proposed Classification of Miscellaneous Previously Unclassified Offenses. Commission staff were recently contacted by criminal justice practitioners regarding 3 offenses that have a penalty greater than 1 year, but are not currently included in the guidelines offense table. The commission's policy is to classify any offense with a penalty of greater than 1 year. Accordingly, this memorandum presents these 3 previously unclassified guidelines eligible offenses along with recommended classifications. On page 2 of the proposed classification memorandum, you will see the first of these 3 offenses, which is a violation of criminal law article section 3-601C1, which prohibits subsequent violations of first and second degree child abuse not resulting in the death of the victim. Under the statute, a person convicted of first or second degree child abuse not resulting in the death of a victim who has previously been convicted of first or second degree child abuse is subject to imprisonment not exceeding 25 years. Comparable offenses are listed on page 2. You'll note that comparable offenses include 2 other child abuse offenses which, like the current offense being considered for classification, carry a possible penalty of imprisonment not exceeding 25 years. So based on these comparable offenses, commission staff recommended to the guidelines subcommittee that this offense be classified as a person offense with a seriousness category of 2. At the June 21st, 2023 meeting, their guidelines subcommittee meeting, the 3 subcommittee members who were present at the meeting voted unanimously to adopt the commission staff's recommendation. Accordingly, the guidelines subcommittee recommends classifying this offense as a person offense with a seriousness category of 2. And at this time, I will turn it over to the commission for any discussion.
Judge Zuniara, you are on mute.
Thank you. Is there a motion to accept the recommendation?
Motion to accept the recommendation.
All right, thank you. Is there a second?
Second.
All right, any further discussion? Seeing none, all those in favor signify by raising your hand. Thank you. Anyone opposed? All right, the motion carries.
Okay, so now moving on to the next offense, which is on page 3, we have the offense of willfully, maliciously, or with intent setting on fire or causing to be set on fire any woods, brush, grass, grain, or stubble. The penalty for this offense is contained in Natural Resources Article Section 5-704A and provides that a person convicted of this offense is guilty of a misdemeanor and is subject to imprisonment not exceeding 5 years and or a fine of between $250 and $2,000. Comparable offenses for this offense are listed on page 3. And based on the comparable offenses, Commission staff recommended to the Guidelines Subcommittee that this offense be classified as a property offense with a seriousness category of 6. And at the June 21st Guidelines Subcommittee meeting, the subcommittee members in attendance voted unanimously to adopt the Commission staff's recommendation. Accordingly, the Guidelines Subcommittee recommends classifying this offense as a person offense with a seriousness category of 2. I'm sorry, I think that's a mistake.
Sorry, Mark, I think that was a property offense as a seriousness category of 6.
6.
That's right. Yeah, that was a typo. I apologize. It is a property offense as a category of 6 that as voted unanimously by the subcommittee. That's property offense, seriousness category of 6. And with that, I will turn it over to the subcommittee for any discussion.
All right. Did anyone have anything to add or questions?
Are you sure it's not 7?
Yes, we are on page 3 of this particular memorandum, and we did discuss this as a 6.
Okay,
I believe that's correct. Yep.
Which is consistent with the comparables.
all right.
All right. Is there a motion to accept the recommendation?
So moved.
All right. A second?
Second.
All right. Seconded. Any further discussion? All those in favor of accepting the recommendation signify by raising your hand. Thank you. Anyone opposed? All right. Mr. Fincy, are you opposed or were you just still saying yes? Okay, the motion carries. Thank you.
Okay, and finally, moving on to page 4, we have the last of the 3 offenses, which is violation of any provision of or failure to perform any duty imposed by a rule, regulation, order, or permit adopted or issued under Environment Article Title 9, Subtitle 2, subsequent offense. The penalty for which is contained in the Environment Article, Section 9-343, subsection A1, II. This offense is a misdemeanor punishable by imprisonment not exceeding 2 years and or a fine of $50,000 per day. Comparable offenses are listed on page 4. Based on these comparable offenses, Commission staff recommended to the Guidelines Subcommittee that this offense be classified as a property offense with a seriousness category of 7. At the June 21st Guidelines Subcommittee meeting, the subcommittee members in attendance voted unanimously to adopt the Commission staff's recommendation. Accordingly, the subcommittee recommends classifying this offense as a property offense with a seriousness category of 7. And with that, I turn it over to the subcommittee for any discussion.
All right. Anyone have anything to add?
I move we accept the recommendation.
Any second?
Second.
All right. Any further discussion? Seeing none, all those in favor signify by raising your hand. Thank you. Anyone opposed? All right, the recommendation carries.
Okay, great. Thank you. So we can now move on to the last item on the subcommittee report. This is agenda item 4C, and this is review of how feigned weapons impact the weapon presence portion of the offense score. And for this discussion, we're going to turn it over to Sarah Bowles on the staff to guide us through an introduction of this topic. Sarah?
Thanks, Dave. Hi, everyone. I'm going to be discussing the memo Feigned Weapons in Part C of the offense score. This issue was first brought to our attention by an assistant state's attorney who was prosecuting a case in which the defendant planted a very realistic looking phony destructive device at a jewelry store in an attempt to rob the store. The attorney was attempting to calculate weapon presence points for the robbery, but noted that the guidelines manual's current instructions for calculating weapon presence points provide conflicting advice. Chapter 6.1c of the manual defines weapon presence as the presence of an article or device which reasonably appears capable of causing injury. The same instructions go on to state that the score shall be 0 points if a weapon was feigned, but no weapon was actually present. Taken together, these instructions may cause confusion. While feigned weapons are not real weapons, they can still reasonably appear capable of causing injury, as illustrated in the Assistant State's Attorney's case. Given the inconsistency in these instructions, the staff asked the Guidelines Subcommittee to review the issue at its June subcommittee meeting. With one member absent, the subcommittee reviewed the issue and voted 2-1 to recommend to the full commission revisions to the manual and COMAR to clarify the treatment of feigned weapons. This current memo provides a review of the guidelines and law related to feigned weapons in Maryland and other jurisdictions and concludes with the subcommittee's proposed revisions to the MSGM and COMAR. The instructions for scoring weapon presence points currently include 3 provisions relevant to feigned weapons. First, as noted, the instructions state that weapon presence means the presence of an article or device which reasonably appears capable of causing injury. Second, the instructions state, except if used as a bludgeon, a toy gun is not a weapon and shall receive a weapon presence score of 0. Finally, the instructions state if a weapon was feigned, but no weapon was actually present, the score shall be 0. These instructions have evolved since the first version of the manual was published in 1981. The instructions providing that if a weapon was feigned, but no weapon was actually present, the score shall be 0, have been in the manual since its first iteration, while the reasonably appears capable of causing injury language was added in the second iteration. It's not clear why this language was added to the manual. It's possible that it was meant to refer to feigned weapons or to unloaded firearms, non-functioning but real weapons, or some other object. The second version of the MSGM also clarified that CO2 guns, toy pistols, and starter pistols are scored as weapons other than firearms. And notably, this language was revised in 1989 following the ruling in Brooks v. State. In Brooks v. State, Maryland's Court of Appeals, now the Supreme Court of Maryland, found that a lightweight toy plastic automatic pistol was neither a dangerous nor a deadly weapon in the context of the state's robbery with a dangerous weapon statute. So directly in response to this ruling, the MSGM was revised to state, except if used as a bludgeon, a toy gun is not a weapon and shall receive a weapon presence score of 0, an instruction that remains in the manual today. Since the Brooks decision, the General Assembly has enacted legislation providing that in a certain scenario, robbery with a dangerous weapon includes something other than the physical presence of an objectively dangerous weapon. Specifically in 2005, the General Assembly passed House Bill 663, which amended the state's robbery with a dangerous weapon statute to include displaying a written instrument claiming that the person has possession of a dangerous weapon. Passage of this law suggests that there is at least one scenario in which the legislature considered an offense involving something other than the physical presence of a real weapon serious enough to place it in the same statutory subsection and penalize it in the same manner as a real weapon. To provide some context for the current discussion of feigned weapons, staff examined the sentencing guidelines data, specifically looking at weapon presence points scored for convictions for robbery by display of a written instrument claiming possession of a dangerous weapon. We identified 5 sentencing events involving 5 convictions for robbery by display of a written instrument sentenced from 2013 through 2022, and no weapon presence points were scored for any of these offenses. However, we did identify 1 sentencing event involving convictions for both robbery with a dangerous weapon and manufacture, possess, transport, or place a phony destructive device. Similar to the earlier scenario, the individual in this case brought a phony destructive device into a store and claimed that it was an actual bomb in an attempt to rob the store. And in this case, 1 point was scored for weapon presence for the robbery with a dangerous weapon charge. Finally, we reviewed how other sentencing commissions treat feigned weapons in the context of their guidelines. Of the 17 jurisdictions that maintain sentencing guidelines, 5 jurisdictions include in the calculation of their guidelines a measure of weapon presence or use that makes an implicit or explicit reference to feigned weapons. Of these 5 jurisdictions, 3 jurisdictions, Virginia, Michigan, and the federal system, provide for an increase in the guidelines when a feigned weapon is present or used in at least some circumstances, while 2 jurisdictions, Pennsylvania and Alabama, suggest that feigned weapons would not be defined as weapons for the purposes of calculating the guidelines. After discussion at the June Guidelines Subcommittee meeting, the subcommittee members voted 2-1 to recommend revisions to the manual in COMAR that would instruct users that 1 point shall be scored for Part C of the offense score if a weapon is feigned but not actually present. Those in favor of scoring feigned weapons with 1 point emphasize the heightened sense of fear and potential for harm that a feigned weapon produces relative to a scenario where no weapon, either feigned or real, is present. So, for instance, regardless of whether a real or phony destructive device is used in the commission of the crime, the law enforcement response is the same as is the victim's sense of fear. And the one subcommittee member who voted against the proposed revisions expressed concern that the instructions may lead to potentially less serious feigned weapon cases being scored 1 point for weapon presence. So, for instance, a scenario where an individual places his finger in a jacket and pretends it is a gun would score 1 point under the proposed revisions. The language for these proposed revisions starts on page 5 of the memo, and there are 3 main changes proposed to the instructions for scoring weapon presence. The first clarifies that an unloaded firearm is considered the same as a loaded firearm, and this was done to make clear that an unloaded firearm would not be considered a feigned weapon. The second revision removes the instruction stating that except if deliberately used as a bludgeon, a toy gun is not a weapon and shall receive a weapon presence score of 0. And the final revision modifies Part G of the instructions to state that if a weapon was feigned but no weapon was actually present, the score shall be 1. And that concludes my summary. I'm happy to answer any questions about the memo, and otherwise I will turn it over to the commission for discussion. Thank you.
Thank you, Sarah. I appreciate that. That was a good explanation. I know that was a little bit lengthy, but honestly, that was a complicated issue that the staff spent a lot of time on. And I want to give credit to Sarah and Kathy and Mark. There was all of us kind of reviewing it. It's complicated, and the subcommittee did have a healthy discussion about this issue, and it was ultimately not a unanimous vote, but a 2-1 vote to come up with the proposal that you see put forward today. So I just kind of wanted to express my appreciation to the staff for their work on organizing this complicated issue. And I'll turn it over to Judge Avery and the other members of the subcommittee if they want to have any input or discussion about that.
I was just going to add that, I mean, we discussed this at length and I appreciate all the views. I think that Mr. Harvey and I both agreed and voted for the second recommendation, which would assign a point with a feigned weapon, because I mean, I'll speak for myself, Mr. Harvey, you can speak for yourself, but I think we felt that it's a complicated issue and that this is kind of a compromise position, acknowledging the scope of harm that does exist when there is a feigned weapon. Mainly, in my opinion, because force is often met with force. So, you know, if someone is credibly feigning a weapon in a robbery situation, that, or in an assault, just an assault situation, you know, to scare someone, that often then there is the response, which also would include a gun or some kind of weapon, and that this does create a zone of harm that is actionable. So that's you know, of course, Mr. Fincy, we figured everyone would have opinions about this, and so I'm just presenting what our majority viewpoint was, and we're very open to hearing from anyone else.
I'll go when you're ready.
Go ahead.
Well, this is a very, very important issue, I say to the commission, and Judge Avery, you sort of expressed my biggest concern in your presentation. You used the words when a weapon is credibly feigned. I think that by what we have written or what's been proposed creates probably the most subjective and ambiguous element of the sentencing guidelines that have ever been in the guidelines. When I first heard of the issue at the subcommittee meeting, the plan of a jewelry store robber to prepare a destructive device, plant it, and use it as a means to rob the jewelry store, that to me it didn't trouble me in the slightest that a feigned weapon would be, in that scenario, be applied to the offense. My concern, as was briefly described in the presentation, was that there are many situations where there's not any object present that could credibly be described as a weapon. And there are many times when weapons may be described by a victim, to create a situation of a more serious offense. I think my concern really is that we need to have a definition of feigned weapon that is objective. And then I think the compromise makes sense. So my biggest concern wasn't that we were establishing a policy of scoring points for feigned weapons, because there are some feigned weapons already in the guidelines. I think, a pellet gun is not a deadly weapon, but it could be used to strike someone, I suppose, and therefore it could be a dangerous weapon, but it isn't a gun. It's not a deadly weapon. So therefore it only scores 1. I think that if we're going to score feigned weapons, we simply need to come up with an objective definition that judges can apply, that judges are able to define what it is that they are scoring as a feigned weapon. And to me, some of the guidelines of the federal definition made sense to me. And this is not a proposal of a definition, but I think that the presence of an object coupled with the intent to create the impression that the object was a deadly weapon is what should be required as something along those lines as a definition of a feigned weapon. Thanks.
Hey, anybody else want to weigh in? Delegate Bartlett, I see you.
Thank you.
There we go.
Okay, I just had a quick question. I understand, and thank you so much for simplifying or attempting to simplify something that is very complicated. So I appreciate the work. With respect to the memo at C under weapon presence, I guess there's a section D. I want to make sure I understand. So D is being removed so that if there is a toy weapon, will receive a 0 score.
Yes, it's being removed such that a toy gun would now receive 1 point under these revised instructions.
Okay, great. Okay, now that I understand. I wasn't looking at it altogether. So yeah, comprehensively. So that makes sense. I thought it was getting taken out altogether. So that's perfect.
Yes.
I think, yeah, personally, I think it was you all did a great job. And just wanted to commend you on that. And I get it. Because the fear is the same. So thanks a lot.
I would also add that with regard to the definition of a feigned weapon, personally, I don't think that there should have to be an object that credibly looks like a gun, because I think that if somebody comes up behind you and has a little piece of PVC plumbing pipe and puts it in your back, that's not, if you saw it, it's not going to look like a weapon. But in that context, it's certainly going to be terrifying. And perhaps if you have your own weapon, you would respond in kind. So that's I think it's the same if somebody walks into a bank with a note that says, give me your money or I'm going to shoot this place up. Same thing. There's another person who observes that, reads that, they may also respond with deadly force. So that's kind of where we were with the debate about whether the feigned weapon should be defined as an object that appears to be, credibly appears to be a weapon.
There are many, 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 many more cases. Those are pretty rare cases. I think we can all agree. There are many, many more cases where somebody on the street has his hand in his dip, and people are saying he has a weapon. Maybe he's reaching for his phone. That is far more common a scenario than the situation that you are referring to, which I have, as I said, less of a problem with. And sticking a pipe into someone's back is an object that is intentionally creating the impression of a deadly weapon, which is within the confines of the definition that I proposed. So, I hear you. I just think that it drags way too many. The definition we have proposed here brings in way too many scenarios where a deadly weapon should not be scored.
I just have a question. You would like for there to be a definition, and that would be in the guidelines themselves, but there's really no substantive definition for the offense itself. Is that my understanding?
What I would propose is that there be a definition inserted somewhere into where, for example, we have the area of the guidelines repeated here, where the individual completing the worksheet shall apply the following rules regarding weapons.
The advice.
We should insert a rule in there defining what a feigned weapon is if it's going to be scored as one point.
I respectfully think that that's almost impossible to do. There's too many varieties of feigned weapons. My focus is on the effect that this feigned weapon has on the victim. And I would focus on the actions of the offender. In other words, that the offender affirmatively represents, either verbally, in writing, or by some action, that he or she is in possession of a weapon. The weapon score would be 1, regardless of whether a weapon is actually displayed or observed. So the focus is on the actions or words of the offender. And if the offender creates that dangerous situation, not only for the victim, for the police, but also for the offender, frankly, then there should be a score of 1. That was my position.
So it's the effect on the victim, basically.
That was my focus, Judge.
All right, I see Mr. Zaramba's been patiently waiting. Let me give him an opportunity.
Thank you, Judge DiLeonardo. In Handy versus State, which is at 357 Maryland 685, at page 692, the Supreme Court of Maryland examined the legislative intent for these crimes. And I just want to read what they had to say. It says, this court examined what constitutes a dangerous or deadly weapon under Section 488 in Brooks versus State. We noted 2 approaches: the subjective test, in which a weapon is deadly or dangerous if the victim believes it to be of that character and is therefore intimidated by its use, and the objective test, in which to be dangerous or deadly, a weapon must be inherently of the character or must be used or usable in a manner that gives it that character. We ultimately adopted the objective test. In doing so, we held that a related statute, Article 27, Section 36, which prohibits the concealed wearing or carrying of a dangerous or deadly weapon, or the wearing or carrying of a dangerous or deadly weapon openly with the intent to injure, embodied the legislature's intent that the trier of fact determine objectively whether the facts supported that an object was used as a dangerous and deadly weapon. I think the proposal here, which would recommend an increased punishment for a feigned weapon based on a subjective belief that a weapon is real, and that having this fact determined by a judge at sentencing rather than the fact finder at a trial, is contrary to this legislative intent. Where there are circumstances in which the legislature has determined that a feigned weapon merits increased punishment, the legislature has done so and criminalized that conduct, such as Criminal Law Article 3403, that criminalizes the use of a note claiming that the person has a weapon as a robbery with a dangerous and deadly weapon. But in these instances, the legislature has determined that the offense should be charged in an indictment and proven to a judge or a jury beyond a reasonable doubt, and that it, rather than having increased punishment determined as a matter of sentencing. So I think, given a clear expression of legislative intent regarding how feigned weapons should be treated under these statutes, that there should, I think the guidelines as they've existed or since 1981 are consistent with that and should remain so. Thank you.
Mr. Zaremba, there's a statute that deals with like a bank robbery note?
Yes.
I was unaware of that.
Yeah, it's actually, I think it's referenced in the memorandum. It's 3403, robbery with a dangerous weapon. And I believe Ms. Bowles pointed out that the legislature in 2005 added subsection A2, which says that by displaying a written instrument claiming that the person has possession of a dangerous weapon, in that instance of a feigned weapon, that is a robbery of with a dangerous and deadly weapon.
Okay, all right. Okay, thank you.
Do I understand correctly that in the 5 cases that were identified, there was some review of some guideline scoring in the past? By the
Yes. Yes, that's correct. And there were 5 cases of the robbery with robbery by a written note. That is what we identified, 5 cases, and none of them scored weapon presence points.
Okay, so the court didn't score any. I got it.
All right, any other comments? None. Is there a motion regarding the recommendation?
So moved.
All right, there's a move. Mr. Fincy, you had something to add?
I had an alternative motion.
Okay, well,
Is it
we got
appropriate
one
now or no?
motion. I'm sorry, you can ask to amend that motion if you'd like.
I would move. Can I ask to move to amend the motion then? Tell me.
Yes, what would that be?
I would move to send the recommendation back to the subcommittee to consider adopting or consider proposing a definition of feigned weapon to include with the overall motion.
I think Ms. Bicknell, you made the original motion. That is up to you whether you wish to accept. I believe, if I'm getting this correctly on order, it would be up to you to accept that amendment or not.
I have no problem accepting that.
Okay, so that is the current motion. Is there a second?
Second.
A second.
Okay, so all those in favor, any further discussion?
I just want to be clear. I thought the committee said that they did consider that or they didn't.
I'll let Judge Avery, if she wishes to weigh in.
You mean the definition?
Yes.
I thought we did, but I am willing to revisit it.
There was definitely a discussion about that, if I may add that. We
Yeah.
didn't get into specifics of it. There was an agreement. One of the subcommittee members wasn't present, so we will have, potentially a full subcommittee to address the issue. We looked at the language that, we briefly discussed it, but we didn't come to a decision about the language that Rick suggested that's borrowed from the U.S. sentencing, the federal guidelines. Well, there was some discussion about whether it has to be an object or not, because that
Exactly.
definition
Right.
uses the word object. And I think some of the pushback was whether it does have to be an object. Is a finger an object? Other things, what do we consider an object?
Wasn't the appendix included? Because I requested to include definitions from other jurisdictions, if I recall.
No, we had originally included that in the memo.
Right, we'd always had that in there.
Okay.
So there is, if you look at the Appendix A on page 10, that's the definition that Rick, I think, loosely put out. I'm not saying was under the United States Sentencing Commission, under the federal guidelines. Rick, you were suggesting, and I'm not trying to put words in your mouth, the definition based off of that would utilize the term an object that, is capable of inflicting death or serious bodily injury, closely resembles such an instrument. Using that type of creates an impression that the object was such an instrument, a deadly instrument, something to that effect.
Yeah, that it's displayed or used with the intent to create that impression. Yes, that was what I was proposing, something to that effect.
All right, very well. So there's a motion and a second as to that. All those in favor can signify by raising your hand.
Excuse me, Mr. Chair, if it
Yes.
just to be perfectly clear, what is the motion that we're about to
So the
vote?
motion was to refer this matter back to the subcommittee to have a discussion on the whether or not and what to include as a definition of feigned weapon before the overall recommendation were considered by the commission.
Okay, thank you very much.
So with that, again, all those in favor signify by raising your hand. All right, anyone opposed? Mr. Harvey indicates opposed. All right, so that motion carries. It'll be referred back to the subcommittee.
Just one quick question. Any
Yeah.
thoughts or comments? We would send those over to Judge Avery before.
Certainly you could do Judge Avery, Dr. Soleil, or really any members of the subcommittee, but
Yeah.
certainly those would both make it to the committee.
Okay, and the subcommittee probably won't be meeting before.
Late August is probably the intention that we would meet, because our next commission meeting is in early September.
Okay, perfect. Thank you.
Right. All right, and with that, Dr. Soleil, I'll refer it back to you.
Okay, great. So that will conclude the subcommittee report. We appreciate everyone's input on that. So we are now going to turn the discussion over to agenda item 5, which is the report on assessment of racial differences in guidelines eligible sentencing events. I'm really pleased to present this assessment to the commission. First and foremost, I really wanted to recognize the hard work of our staff to complete this report. There were many discussions and meetings to discuss the various analyses that were utilized in the report, and then what to include in the report, and then how to write the report and to present the information. I think that, and I hope you agree that I think it's a very thoughtful and thorough report. And we did our best to present the information in a commonsensical, meaningful way as well. But I just wanted to recognize the really significant efforts of the staff. It really was a group effort, but in particular, I wanted to recognize Stacy Najeka, who is our research director, and Sarah Bowles for our program analysts for their work. They really put in a ton of effort into completing the report. So I just wanted to start with that acknowledgement. I also want to thank the commissioners that provided feedback on the report that we distributed on June 15th. We have incorporated that feedback and included our own additional, by us, I mean the staff, additional non-substantive edits. So we will have that ready. Sarah will now provide a presentation about the report. We know it's long, but we wanted to kind of hit some of the highlights from the report and provide that as an overview to the commission. And then I will wrap up by discussing the report recommendations. Our plan is to, the recommendations, there is a call for action for the report recommendations to see if the commission would approve the recommendations and then call for discussions about those and hope to take action to vote to adopt those recommendations. So with that introduction, I will happily turn it over to Sarah. And Sarah has a presentation that she'll go ahead and display. So thank you, Sarah. You are on mute, so just take yourself off mute.
Thank you, Dave. Let me just pull up this presentation. All right, I think everybody should be able to see the slides now.
Yes, we can see it. Thank you.
Okay, great. So the purpose of this presentation is to provide a brief overview of the Commission's report on race and sentencing, with particular attention paid to key findings and recommendations. I'll begin the presentation with a brief background of the report and data used for the analyses, and then I'll review key findings from the report. Finally, Dr. Soulé will provide a summary of the report's recommended actions for the Commission and other agencies. And following the presentation and discussion, commissioners will be asked to vote to adopt the report's recommendations. Since there are several newer members of the Commission, we thought it might be helpful to provide a bit of background on how the report came about. The Commission first initiated a review of racial differences in guidelines-eligible sentencing events in 2020. At this time, the Commission initiated a series of analyses to examine the components of the sentencing guidelines to assess whether racial differences are exacerbated at sentencing. 2 years later, the topic was brought up again during the Department of Legislative Services February 2020 review of the Commission's fiscal year 23 budget. Each legislative session, as part of its consideration of the state's operating budget, the Maryland legislature reviews the proposed budget for the Commission. During the February 2020 review of the Commission's fiscal year 23 budget, an analyst from the Department of Legislative Services recommended, and the Legislative Budget Committees agreed that the MSCCSP develop a plan for studying the extent to which racial bias is present in sentences assigned through Maryland courts. In response, the Commission provided testimony concurring with the recommendation and agreeing to provide the requested plan. On May 10, 2022, during the Commission's business meeting, commissioners reviewed and provided feedback on staff's proposed outline of the study plan. A more detailed plan incorporating commissioner feedback was provided to commissioners on June 30th, 2022, and subsequently submitted to the legislature on July 15th, 2022. More recently, on June 15th of this year, the draft of the full report was provided to commissioners. And as indicated in the study plan, the report will be submitted to the legislature on or before July 15th. The report provides a descriptive analysis of racial and ethnic differences in sentencing, and it's limited to guidelines-eligible sentencing events in Maryland and thus describes a subset of cases prosecuted in the state. Cases originating in circuit courts account for most guidelines-eligible cases. Among those cases excluded from guidelines coverage are all cases prosecuted in the district court. The analyses presented in this report use data records for sentencing guidelines worksheets completed for sentencing events in calendar years 2018 through 2020, which includes nearly 30,000 sentencing events. And the racial ethnic categories used for this report are Black, White, Hispanic, and other. The analyses examine various sentencing related factors by race, including judicial circuit, criminal history characteristics, offense characteristics, disposition type, sentencing trends, and sentencing guidelines compliance. So we're going to look at 3 sets of findings. This first set of key findings provides an overview of the racial demographics of guideline sentenced individuals. In calendar years 2018 through 2020, the majority, 63.4% of guideline sentenced individuals were Black. In comparison, 29% of sentenced individuals were white, 6.2% were Hispanic, and 1.4% were of another race. And there are a couple of important points we want to highlight about these demographics. First, the racial differences among guidelines individuals are present before sentencing. Various factors that occur before sentencing, including arrest practices and charging decisions, impact the demographics of those individuals who ultimately come before a court for sentencing. Second, the relatively small number of Hispanic and other race individuals sentenced during this time period will be important to keep in mind as we review the study's findings. Caution should be used when interpreting results from such small populations, particularly when they are broken down into even smaller subgroups, which we do in this report when looking at, for instance, offense type and jurisdiction. This slide displays the race of guideline sentenced individuals by judicial circuit. Relative to the other circuits, the 8th Circuit was comprised of the largest percentage of Black guideline sentenced individuals, while the 6th Circuit was comprised of the largest percentage of Hispanic individuals. Guidelines eligible sentencing events in the 2nd Circuit were comprised of the largest percentage of white individuals relative to the other circuits, though the total number of sentencing events in the 2nd Circuit was comparatively small. The report included this analysis of race by circuit because it's a common question the Commission receives. However, it's important to stress that there is notable variation in the racial composition of the general population of the jurisdictions that comprise the respective circuits. And therefore, we would expect to see differences in the racial demographics of individuals sentenced in each circuit. This next set of findings looks at the criminal history of guideline sentenced individuals, as well as offense and disposition characteristics by race. As you know, an individual's criminal history and offense characteristics are what ultimately determine their recommended guidelines. Here we have the mean offender score by race. The offender score is a composite measure of individuals' prior adult and juvenile criminal records. Black guideline sentenced individuals were more likely than sentenced individuals of all other races to have serious prior criminal records or higher offender scores and less likely to have no prior criminal involvement. Supplemental data, which I'll review on the next 2 slides, suggest that the higher offender scores observed among Black individuals were due to their accumulation of a greater number of prior serious convictions than Hispanic, white, or other race individuals. As you can see here, supplemental data obtained from the Department of Public Safety and Correctional Services for a previous commission study showed that approximately 61.5% of Black guidelines individuals sentenced from 2008 to 2012 had 1 or more prior adult conviction, while only 53.3% of white individuals had any prior conviction, and a much smaller percentage of Hispanic and other race individuals had any prior conviction, 29.3% and 28.9% respectively. Black individuals also had on average more prior convictions than individuals of other races, with an average of 2.6 prior adult convictions. White individuals had an average of 2 prior adult convictions, and in contrast, Hispanic and other race individuals had an average of less than 1 prior conviction. Black sentenced individuals also on average had more serious prior convictions than individuals of other races. This figure displays the seriousness category of the most serious prior adult conviction by race. And this measure is important because it's used to calculate the individual's prior adult criminal record score, which is Part C of the offender score. And the more serious one's prior convictions, the higher they will score on the prior adult criminal record, the higher their total offender score will be, and therefore the higher their recommended guidelines will be. As you can see here, the most common seriousness category of prior conviction for white, Hispanic, and other race individuals was seriousness category 7, which is the least serious category of offenses. While the most common category for Black individuals was seriousness category 3. Nearly 1/3 of Black guideline sentenced individuals had at least one prior seriousness category 3 conviction. Most common seriousness category 3 offenses being felony narcotic offenses, such as possession with intent to distribute, distribution, and robbery with a dangerous weapon. So on average, Black sentenced individuals had more prior adult convictions and more serious prior adult convictions than individuals of other races, thus leading to higher recommended guidelines and potentially longer sentences than individuals of other races. This slide looks at the mean offense score by race. The offense score is calculated for person offenses only, and it's a composite measure of the characteristics of person offenses, including the seriousness category of the offense and whether the offense involved any victim injury, weapon presence, or special victim vulnerability. As you can see here, the average offense score was higher among Black and Hispanic individuals relative to white and other race individuals. And if you look at the individual components of the offense score, you can see the factors leading to the higher average scores. This figure here illustrates each component of the offense score by race. The higher average offense score among Hispanic individuals is due in part to the seriousness category of offenses for which they are convicted. Approximately 16% of person offense sentences among Hispanic individuals involve seriousness category 2 offenses, most often child sexual abuse. While the higher average offense score among Black individuals is due in part to the fact that Black individuals were more than twice as likely as individuals of all other races to be sentenced for person offenses involving the presence of a firearm. Further, as we'll look at on the next slide, Black and Hispanic individuals were more likely than white or other race individuals to be sentenced for firearms or weapon offenses that carry mandatory minimum penalties. Here you can see the percentage of felony firearm offense sentences that involve mandatory minimums by race. Among Black individuals, 79% of felony firearm sentences involve mandatory minimums. Among Hispanic individuals, this figure is 62.5%. In contrast, among white individuals, only 41.5% of felony firearm sentences involve mandatory minimums. The most common felony firearm offense carrying a mandatory minimum is a violation of Public Safety Article 5-133C, which prohibits the possession of a regulated firearm after having been convicted of a crime of violence or select drug crimes. And this offense carries a 5-year mandatory minimum sentence. And it's important to keep in mind here that once an individual is convicted of an offense carrying a mandatory minimum penalty, the judge is required by law to impose at least the minimum sentence. This slide illustrates disposition types by race. Disposition types were similar across races, though sentencing events involving Black, Hispanic, and other race individuals were more likely than sentencing events involving white individuals to be disposed of via an ABA plea agreement or what is now known as an MSCCSP binding plea agreement. This final set of findings looks at sentencing trends and sentencing guidelines compliance by race. This slide displays overall incarceration rates and post-sentence incarceration rates by race. Black and Hispanic guideline sentenced individuals were more likely than white and other race individuals to be incarcerated, and as we'll see on the next slide, more likely to be incarcerated for longer periods of time. Some of these differences can be attributed to the differences in criminal history and offense severity noted previously, while some of the differences may also be attributed to the mandatory minimum penalties that apply to certain firearms and weapons offenses. Notably, the difference in incarceration rates are reduced when looking only at post-sentence incarceration. Post-sentence incarceration excludes individuals whose only incarceration consisted of credit for time served. What this indicates is that differences in pre-trial or pre-sentence incarceration influenced overall incarceration rates. This slide illustrates the median non-suspended sentence length by race. Similar to incarceration rates, Black and Hispanic individuals on average received longer sentences than white and other race individuals. Though again, the racial differences are reduced when looking only at post-sentence incarceration. One of the Commission's primary measures used to evaluate consistency in sentencing is guidelines compliance. And as you can see here, sentencing guidelines compliance rates were similar across races, with Black sentenced individuals most likely to receive a sentence that was a departure below the guidelines, and Hispanic individuals most likely to receive a sentence above the guidelines. The similar compliance rates across races indicates that when individuals' criminal history and offense severity, two factors considered by the judge relevant to the sentencing decision, were accounted for, differences in sentences between races were generally reduced, though not eliminated. This reduction was also evidenced by findings of the median sentence as a percentage of the guidelines midpoint across races. As you can see here, the median sentence as a percentage of the guidelines midpoint is nearly identical among Black and white individuals, whereas the median value for Hispanic individuals is higher than that of other races. There may be several reasons for this difference. As we saw earlier, Hispanic individuals were more likely than those of other races to have no prior criminal record, but to be sentenced for relatively serious offenses. It's possible that judges are placing more emphasis on the severity of the current offense than the prior record when sentencing particularly serious offenses. As I noted previously, though, the findings pertaining to Hispanic individuals should be interpreted with caution, as they made up a relatively small percentage of the total guidelines population sentenced during this time period. So wrapping up, we can conclude from these findings that the observed differences in sentences between racial categories were largely, though not entirely, explained by the seriousness of the convicted offense and the length and severity of the prior criminal record. And in this regard, the Maryland sentencing guidelines generally appear to be achieving their purpose. That being said, there are two primary limitations with the current research. First, the data do not address criminal justice system decisions occurring prior to or following the sentencing decision. And second, the data are limited to circuit court sentences for guidelines eligible cases and do not address all criminal sentencings in Maryland. And when we get to the recommendations, you'll see we make some suggestions for future research that would address these limitations. And that concludes my summary of the study and its findings. I'm happy to answer any questions about the report's analyses. And otherwise, I'll let Dr. Soleil review with you the report's recommended actions for the Commission and other agencies.
Okay, thank you, Sarah. Really appreciate your presentation. And thank you for hitting on the highlights. I think if it's okay with everyone, I would prefer if I just go through and present the recommendations, because again, we are calling for action on the specific recommendations. So Judge DiLeonardo, if that sounds okay with you, I would just proceed. Sarah, can you go?
That sounds good. Yeah,
thank you.
yeah.
Sarah, can you go to the next slide? Thank you. The recommendations, we divided them into two parts. The first part focuses on actions that the MSCCSP can address. The second part focuses on recommendations that other state agencies or the legislature or other decision makers in Maryland may consider. As noted in the report, it is important to recognize that the differences in the racial composition of individuals at sentencing are present before sentencing. In other words, there's other factors, societal factors, arrest practices, charging decisions, pre-sentence detention, et cetera, other factors that impact racial and ethnic differences before an individual is sentenced. And while those factors are outside of the scope of the sentencing judge and the Sentencing Commission, the MSCCSP can and should continue to work to ensure that individuals are treated fairly at sentencing. Specifically, the Sentencing Commission should assess whether additional actions may be taken with respect to the sentencing guidelines to ensure racial equity, considering pre-sentencing differences between race. Accordingly, we presented for your review the following recommendations for the Commission to help improve equal justice through its own research and its own policy decisions. So first, the first recommendation is that the commission should plan to assess the impact of the July 2022 revisions to the sentencing guidelines matrices for drug and property offenses with respect to differences in sentencing by race and ethnicity. It is anticipated that this analysis can be completed in 2026 after we have 3 full years of data collected, and we'll have an opportunity to review and assess that data. The second recommendation is the commission should continue to emphasize through training and other forms of communication that both the juvenile delinquency and prior adult criminal record calculations should not include adjudications for offenses that are no longer criminal acts in the Maryland Code. In particular, this education and informational campaign should emphasize that possession of 2.5 ounces or less of cannabis is now decriminalized in Maryland effective January 1, 2023. And given that Black individuals have an increased likelihood of arrest for cannabis possession, the commission should work to reduce the impact of disproportionate cannabis-related criminal justice activity by emphasizing that prior cannabis possession convictions involving 2.5 ounces or less shall be excluded when calculating both the juvenile record and the prior adult criminal record components of the sentencing guidelines offender score. Next, because the report reinforced that Black sentenced individuals accumulate more extensive prior criminal histories in comparison to white sentenced individuals, the commission should consider conducting an analysis to assess the quantity and types of offenses that comprise an individual's prior criminal record and assess differences by race to determine whether steps may be considered to reduce the impact of differential exposure to the criminal justice system. For example, the commission may consider whether the prior adult criminal record matrix should place less emphasis on low-level misdemeanors and or exclude prior convictions after a certain period of crime-free time. Fourth, the commission should review the feasibility, advantages, and disadvantages of amending the Maryland Automated Guidelines System to add a tool to assist with the calculation of the prior adult criminal record. An automated tool would enable the Sentencing Commission to directly collect data about the specific convictions that are included in the prior adult criminal record, providing direct access to criminal history data. And it may help assist practitioners to more easily score the prior adult criminal record. Finally, because prior research from other states indicates that minorities have lower odds of receiving an alternative to incarceration and are less likely to receive non-custodial sanctions, the Sentencing Commission should examine the utilization of corrections options and alternatives to incarceration to assess potential disparities by race and ethnicity. Sarah, could you move to the next slide, please? So on the next slide, we have recommendations for others. As I noted previously, there are many additional factors that may impact the observed differences in sentencing that are outside of the scope of the Sentencing Commission or beyond our resources. These differences may be the result of disparate practices, but this report cannot speak to that because of the limitations of the data as Sarah reviewed. So additional research would be necessary to obtain and analyze data from a variety of outside sources to assess disparity. Accordingly, this second set of report recommendations offers guidance to other state agencies, state legislatures, and other decision makers to help assess and address a few of the many factors that lead to differences in sentencing outcomes for minority offenders. The first recommendation is that the state should consider funding a study similar to the 2020 Harvard Law School study to complete a comprehensive analysis regarding the impact of race at multiple points of the criminal justice system to better understand potential sources of disparity. Specifically, a study should be commissioned to collect data to address potential differences in arrest, pretrial detention, and prosecution charging decisions. Further, because the this report cannot fully account for all relevant considerations at sentencing, future research should consider a multivariate statistical analysis that simultaneously controls for many relevant considerations. Next, the report highlights that one of the driving factors behind the observed racial sentencing differences for felony firearms/weapon offenses is the discrepancy in convictions for offenses involving mandatory minimum penalties. As it was noted, approximately 79% of felony firearm weapon offense convictions among Black guidelines eligible individuals and 62.5% among Hispanic guidelines eligible individuals involved a mandatory minimum penalty, while only 41.5% of firearm convictions among white guidelines eligible individuals involved a mandatory minimum penalty. Accordingly, the second recommendation is that the state should complete a comprehensive analysis to study mandatory minimum sentences and include an assessment of how the presence of mandatory minimum penalties impacts subsequent pleas. Third, because the sentencing guidelines data indicate that Black and Hispanic sentenced individuals are more likely to be detained pre-sentence, and at least for those sentenced under the sentencing guidelines, racial differences are more significant with respect to pre-sentence detention, the state should complete an analysis to examine the impact of race on pre-sentence detention for all individuals sentenced statewide. And this is important because time served prior to sentence may be an indirect source of observed sentencing practices. For example, prior research, as we cited in the report, found that after controlling for other relevant factors, bail and pretrial detention increased an individual's likelihood of pleading guilty, being convicted, being incarcerated, and receiving a longer incarceration sentence. The final recommendation is that the state should explore whether there are unique factors influencing sentencing decisions for Hispanic individuals. This recommendation stems from the finding that Hispanic individuals are more likely to have no prior criminal record, but to be sentenced for relatively serious offenses, particularly crimes of violence. Further research may help to assess whether immigration status has any impact on the measurement of prior criminal record history and/or the sentencing decision. Finally, given the reported concerns with accurately identifying the Hispanic population in the sentencing guidelines data, future research should assess whether alternative methods can be used to improve the measurement of the sentenced individual's ethnicity. So I will end there after presenting those recommendations. I'm sure there will be plenty of discussion. So I guess Judge DiLeonardo, I will turn it over to you. We are happy to address any questions the commission may have.
All right, very good. Well, before we start, I will just say too, job well done by you and all of the staff. It was very impressive, the amount of data and the amount of analysis you provided. So I thank you very much. It was a long read, but it was a very educational read.
I appreciate it. We understand it was a long read. You know, there wasn't a lot of analyses that were included, and actually we put a lot of effort into trying to condense all the analysis that we did include, if you believe that or not.
No, I mean, it was very, very well done, and I really very much appreciate that. Let me open it up to the commission. Is there anybody that would like to weigh in on either the report itself or any of the recommendations? Okay, I don't see anyone. Okay. Well, with that,
I think there's a hand up.
I see a hand up now. Okay, hold on. Unfortunately, I have a limited view on my screen at the moment. Here we go.
It looks like Angela Guarino has her.
Oh, okay. There we go. Yes. If you go ahead and please weigh in.
Thank you, Chair. I just wanted to allow some time so we weren't all rushing at once. First off, on behalf of the department, I certainly want to congratulate a lot of the findings and specifically the attention that the researchers turned to in their selection of how to break this data down. I certainly felt like there were a lot of takeaways for us to take back to our staff. And I absolutely want to concur with the recommendation to specifically focus on continued training for criminal justice positions, specifically those within our Division of Parole and Probation. As the department continues its mission to fill its vacancies, I think it is keenly aware of those training opportunities that have an immediate impact on keeping up those standards, especially those that may disproportionately impact certain groups. So we not only are in agreement with that recommendation, but certainly will be a faithful partner in helping to facilitate the additional training for that group. I think one of the questions that I just had was surrounding the previous the fourth recommendation for the group. I don't know if it's possible to go back a slide. I just wanted to open the discussion a little more for the review of the feasibility advantages and disadvantages of amending MAGS to add a tool to assist with the calculation of adult criminal record. Would it be possible to discuss just a little more what perhaps that recommendation is envisioning as far as the source of that information and the level of information that would be necessary in order to provide those types of answers for individuals using those worksheets. I do think, just on its face, any opportunity to improve standardization and consistency in records like that, especially when there is the benefit of a data source that can be referenced, is something that I think is a best practice. And to that extent, I think the department agrees. We just want to understand a little more, and maybe that's further down into what the feasibility would be reviewing, but just understanding the scope of the recommendation.
No, I think that's a good question. I appreciate the question. So let me backtrack where that comes from, right? For those that are, haven't calculated the guidelines before, the prior adult criminal record is a fairly complex process in order to come up with the calculation, because ultimately it is coming out with a score whether there's no prior criminal record, minor, moderate, or major. And there is another matrix. We have our regular drug, property, and person matrix, but there's an prior criminal adult matrix. And basically what it requires is that the person who's scoring the guidelines, which as a reminder, typically is a parole and probation agent if a PSI is ordered, which happens about 20% of guideline eligible sentencings. For the other 80%, it's the prosecutors who are scoring that information. And what it requires them to do is to go through the individual's prior criminal history using the rap sheet data, most likely. It's going through that and basically counting up the number of priors they have. And the way the matrix works is it asks for you to count, go through and score each of the prior convictions, figure out what their seriousness category is, right? So you have to kind of do some cross-referencing there. You have to say, okay, this was a prior marijuana possession. Well, that would now be excluded, so that's not a good example. Let's say cocaine possession, which is now also a category. That's a category 7 offense. So they have one category 7 offense. Okay, then they also had a PWID offense, a PWID for narcotic. That's a category 3B offense. Okay, so I mark off, I have one of those. And you have to go through and count up. And the way this matrix works is you get a score based on the accumulation of the number and seriousness of prior criminal records. And as you can probably expect just from me explaining to that, it is a complicated process and requires a lot of input. And what we're suggesting, and this is the reason why we worded it as the feasibility and advantages and disadvantages, is because we would really need to explore like how much we could automate that process. I have had discussions with your folks, Angelina, many years ago about whether we can automate it so that literally we can, the individuals scoring the guidelines, we would be able to pull that information out of CGIS and then cross-reference it against our guidelines offense table and say, okay, PWID is a category 3 offense, possession of cocaine is a category 7 offense, and do the calculations and then spit out what the appropriate prior criminal record score is in the guidelines. The other more simplified version of that would just be to build a tool in MAGS where, like, if Mr. Harvey was scoring the guidelines in Calvert County, he would enter and say, okay, one prior conviction for PWID in 2020 and one prior conviction for possession of cocaine in 2022. And then that tool would just score what that would work out to. It would say, okay, well, we already, he wouldn't have to look up that it was a category 3 and a category 7 and then go across the matrix and figure out what number of combination of category 7s and category 3s adds up to a moderate or major record. And so there are some advantages. The advantages to that is that if we build that tool into the application, we then have that data to directly assess ourselves later on. And which we don't now, right? We don't have the criminal history. We have to go to public safety and ask for the rap sheet data, which is a difficult, at least in the past, it's an onerous process to go through that data and essentially do all that recoding that describes it. We have to match it up with our offense table and assign seriousness categories for all the offenses, et cetera. So there's two advantages. The advantages we think are that we get direct access to the data that goes into it, that would be now included. But the major advantage we think would be to help assist those that are calculating the guidelines and simplify the process for them. There probably are disadvantages to it. For instance, when we first did a pilot of MAGS, we had such a tool in there. And the feedback that we got was it was clunky and it was slowing down the process. So I think we could do better now. We have a lot of experience with the development of MAGS and the multiple different iterations of it that we've rolled out. So I think we could do better, but I do definitely think that there might be some pushback about anything that would slow down the process. Our goal would not be to slow it down. It would be to simplify it and help those who are scoring the guidelines.
Thank you for that background. It is very helpful for those, I think, few of us who have not directly filled out a sentencing guidelines worksheet.
And maybe I left out the punchline on there. If we have the data directly, it's much more easy for us to assess whether there are differences by race for the criminal history record. So maybe I should have led with that. How is that related to a report on racial differences?
All right. Well, I'll ask really two questions, David.
Sure.
First of all, on the recommendation, there is the last one, which is to examine the disparities exist in the utilization of corrections options and other alternatives to incarceration. I recall, and you made that point, or the presentation made the point about that pre-trial incarceration may account for some of the sentencing differences.
Right.
As the reason to do this. I recall years ago, my prior time on the commission, there was at one point a lot of discussion about what pretrial options there were in different jurisdictions. And there was no doubt wide variety of services. For example, in my county, we have a very strong pretrial. We can have people tested weekly, daily if we need. We have GPS, we have sobrieters. We have a lot of pretrial ability so that we could put people in the community with a lot of supervision, where I know there's other places in the state that have nothing close to that.
Right.
So it's either incarcerate or let them go with no supervision. And I'm just wondering, as a result of that, on this last factor, what is the thought on how this would be done?
That's a good question, because as you're recalling correctly, Judge DeLeonardo, we did have extensive discussions about this. Remember, we did a study assessing the utilization of corrections options and alternatives to incarcerations a few years back. And we ultimately decided that study should focus on alternatives that are utilized by judges at sentencing. But as you are very appropriately pointing out, there's a much larger body of alternatives and diversion programs that are utilized pre-sentencing. And, that is data that the Sentencing Commission doesn't have. I mean, it's something, our data severely undercounts, for example, drug court, utilization of drug court throughout the state, because a lot of the way drug court works is it results in deferred sentencing. So if someone goes into drug court and successfully completes it and their sentencing is deferred, there's no guidelines worksheet filled out. So
it's all predisposition.
Right. Yeah. So it's all done predisposition. So, I mean, you're bringing up a very good point. It's almost like this recommendation could be both the Sentencing Commission looking at the utilization of alternatives to incarceration at the point of sentencing with the data that we collect, but also making additional recommendations that the state should really be focusing on pre-trial alternatives and diversion programs. And diversion programs, I know just from my own prior research, I have there's some really high quality diversion programs that are being utilized in some jurisdictions in Maryland, and that really should be emphasized and focused on. And what we really want to explore, is just something we haven't done before, which we didn't do in the prior iteration of the corrections option report, was to assess whether these alternatives are being utilized in a proportionate manner by race.
Right.
And if they're not, then that certainly would be an educational tool that we would want to be able to utilize that information to make sure we're informing judges, prosecution, defense attorneys about that and making them aware of that issue. So it's more about like, is there an issue there? And it's something, if there is, making sure that the Sentencing Commission uses our ability to raise awareness about that issue.
All right, so I guess just so I understood, so the idea would be to identify what options or alternatives there are, then do an analysis as to how they're being used based on race.
Yeah, I think so. We did, as you pointed out.
I think there's so much variation in jurisdiction. I was trying to get somewhat a handle on how you would accomplish.
Yeah. And I won't jump on it. I think Judge Avery, I know this is a passion of hers. And so maybe I'll let her weigh in and share her thoughts about alternatives to incarceration. Because I know, Judge Avery, that's something that you you were a big part of the committee when we went through those recommendations. And we talked about this issue about the availability of alternatives and how they vary tremendously by jurisdiction. So
Right.
I thought it's something you might want to weigh in on.
Well, thank you. Yeah, in 2018, I can't believe it's been 5 years now, but I know when we studied the availability of alternatives to incarceration, we issued a report, the commission issued a report that was unfortunate. It kind of showed an unfortunate disarray across the state, even in jurisdictions where there were effective alternatives to incarceration, whether the justice partners in that jurisdiction didn't necessarily know what those alternatives to incarceration were. And so this has become like a passion project for me for the past 5 years, is to try to develop some programming around making sure that judges and all of the justice partners understand what resources are available to them in their own jurisdictions, but also to examine the disparities from one jurisdiction to the next in terms of what programs are available. To me, this goes to the heart of the structural inequality that the studies that we're doing are designed to remedy. And so I think that what I would like to see is a little bit more development of the recommendations around in our report around studying disparities that exist in alternatives, the availability and the resources for alternatives to incarceration. So it's still within the scope of studying differences or disparities in that department, whether it's pretrial or post-trial. And also, so that would be like a MSCCSP recommendation, is that we can engage in further study on that, but as a recommendation to our justice partners to say that the justice partners should work toward a unified system of information and access so that we can all be on the same page, so that the probation agent knows the same, has access to the same information that the judge has, that the bail review judge, that the pretrial services people have. So, I mean, in my dream world, that would lead to a unified, secure website that would have, that would be searchable by justice partners to identify programming that is customized to an individual. So if it's a dual diagnosis or drug treatment or abuser intervention, mental health services, things like that. So, all right, I don't want to go on and on about that, but I would like to see a little bit of that referenced in this report. And I will tell you, just to be completely transparent, that I think that that is something that is leverageable. If it's in our report, it makes it easier for those of us who are still trying to work toward this outcome to be able to point to in this report. So that's I don't think it will take a lot of addition. I don't think it's going to take a lot of work. I think it's just essentially a few sentences in the recommendation section, page 53 and 54, is let's see, paragraph 5, utilization of corrections options and other alternatives to incarceration, and then adding a recommendation to other state agencies that would make reference to that as well. I think you're muted, Dave.
Sorry, I was keeping myself on mute to make sure. Okay, so if I am hearing you correctly, you're proposing that we expand on the 5th recommendation under recommended actions for the MSCCSP, and additionally add a new recommendation under recommendations for other criminal justice partners, just to emphasize like what you've described as this, like the dream scenario about, having a unified website that is searchable and provide information about alternatives to incarceration. I think that's something that the staff, I think, would be comfortable with making that level of, change to the recommendation. So I would, we could certainly do that if that is the desire of the commission.
All right, I see, Ms. Guarino, you got your hand up.
Thank you, Chair. I just wanted to state on the topic of that last recommendation, DPSCS has, I think, something of a unique perspective on this, being that we do facilitate the pretrial release supervision for Baltimore City as well as home detention. And that is, to my understanding, the only jurisdiction within which both of those alternatives to incarceration do not carry a direct economic penalty to the defendants to whom they are available. And I think that speaks to the importance of the language of this recommendation. I just wanted to, make a note that I think the language of utilization is very important and should be preserved in the recommendation, because there is a wide gulf between availability and accessibility. And we know that specifically impacts different groups differently. And speaking, to the highlighting that was done in this report on the difference in length of sometimes significant criminal history amongst different groups, that is just another example of how, and this is something that we have confronted internally as well, sometimes structural statutory eligibility criteria for some of those programs can inadvertently have different impacts than they perhaps were originally intended to. So I think utilization is an appropriate benchmark. I don't think it's incompatible at all with a comprehensive survey of availability, but I think it's a nuance that's important to keep coupled with understanding that landscape is not just, how many county or county equivalent jurisdictions, for example, have have a pretrial release option, but in how many of those instances does that pretrial release come without an additional cost?
Angelina, I just want to express to you that that is such a good point. And I love the sensitivity of looking at the structural ways that that people are limited from some of these programs and how that may cut along racial lines. But we don't know unless we study it.
All right, very good. Is there any other comments? All right, seeing none, I guess, just short, you had,
I just want to say that I thought it was a very comprehensive report and very well done. And with the exception of the recommendation by Judge Avery, I would move that we accept the report. But I would note that if we were to make the suggestions from Judge Avery, would that impact the time frame that it's being distributed? How would that work?
So I don't think it will. I mean, we promised this by July 15th. And to David's dismay, when I called to talk to him about it at like 5:15 before this meeting, I you know, and I apologize for that, but I think that I really don't think that this is an elaborate addition to the report, and I think that we can get it done in the next couple of days.
Well, what does he say?
Thank you, Judge Shaw. I appreciate your input on that. I did make Judge Avery promise that she would help to draft these few sentences that might be added, because I expressed some hesitation about being able to complete that within the timeline. And I do think that we can make those amendments. We certainly left open the possibility that there would be some edits and amendments related to the recommendation. So we are happy to work with Judge Avery, and I think we can reasonably expect to do that by Friday, because the 15th is actually a Saturday. So hopefully I think we can accomplish that.
So with that, my motion, I would still put it forward and request a second.
all right, is there a second?
I second.
Judge Avery seconds. Any further discussion? Okay, all those in favor of the motion signify by raising your hand. All right, very well. Anyone opposed? All right, the motion carries with the recommendation with the adjustments from Judge Avery.
All right.
So
So
with that, Dr. Soule, it's to you and your report.
yes, thank you so much. So I'll keep this brief. I have a short report today. So I appreciate everyone's patience. I know this is a little bit longer meeting. Just a couple items to get through. Just wanted to provide an update about July 1, 2023 offense table updates. So these are updates to the guidelines with respect to the offense table. The commission adopted a revised offense table to reflect the classification of a new cannabis cultivation offense enacted by Chapter 26, House Bill 837, Acts of 2022. To account for this new offense, the commission issued new versions of the Maryland Sentencing Guidelines Manual and the Guidelines Offense Table, and the corresponding updates were adopted in the Code of Maryland Regulations effective July 1. The staff distributed the guidelines e-news on July 1 to inform practitioners about this update. The e-news also provided another reminder that pursuant to guidelines rule, adjudications based on acts that are no longer crimes should be excluded from both the juvenile delinquency and the prior adult criminal record component. This reminder is relevant because of the recent decriminalization of cannabis possession, which we just discussed in the report recommendation. So we have already implemented one of our recommendations with respect to making sure that we are educating, informing everyone about what the impact of decriminalization has on the scoring for the prior criminal record component of the sentencing guidelines. And also, it's also not just the adult criminal record, it also would apply to the juvenile record. The second update I just wanted to give is about sentencing guidelines trainings and judiciary feedback sessions. On June 16th, Catherine Pembroke, who is our training coordinator, and I provided a judicial education webinar titled Utilizing Guidelines to Support Fair and Just Criminal Sentencing. We were happy to provide this webinar. It was attended, it was pretty well attended. I think we had about 20 judges that participated in the webinar session. And we also had some good questions that came out of it. So I think that was a really great opportunity. Additionally, I met with the judges and court staff from multiple jurisdictions since our last meeting. Meetings were completed with the judges in Frederick County on May 31st, Prince George's County on June 15th, and in Montgomery County yesterday on July 10th. Additional meetings are scheduled in Carroll County with our chair and his colleagues for tomorrow. So I will be traveling out to see our chair and his colleagues.
We're even going to give you a free lunch, David.
That's right, and I greatly appreciate that. And then also planning for scheduling upcoming meetings in Howard County. So that is just continuing. My goal is to get out and meet with each jurisdiction every 2 to 3 years. The last, it's really been, I've been sticking much closer to the every 2 years. They are a great opportunity to share information about the sentencing guidelines, provide updates. Obviously now I'm making sure to emphasize about the changes with respect to scoring the prior criminal record and cannabis decriminalization, et cetera. So it's a great opportunity to share this type of information and also to ask for feedback from the judiciary regarding the sentencing guidelines and the work that we do. So I really appreciate having those one-on-one opportunities. They've been really great. So that will conclude my executive director report. I will ask if I could sorry, I remembered I wanted to circle back, if you indulge me, to the race analysis, just as a final wrap up. Our plan would be to distribute that report pursuant to legislative reporting requirements. So you don't all need to know what that means, but in order to officially comply with what we said we were going to do, we will send 5 copies to the legislative library and et cetera. But our plan would also be, if there are no objections, that we would post this report to the commission's website, and also that we would distribute an email that would provide a link to the website so that people can read the report. So just like we do with our annual report, that we would distribute it to our same distribution list, which, Catherine, please correct me if I'm wrong. I think we're up to about 600, 700 individuals around the state that receive that. When we send out, for example, the guidelines e-news, we send it out to that same group. So just to raise awareness, to let people know about the report, and I'm sure that will generate some interest. So if there are no objections, that would be the plan with regard to the race report once we have it finalized.
All right, very good. Well, as far as remaining meetings for this
David?
year. Yes.
Excuse me, Judge.
Yes,
I'm Harvey. Can I just make a suggestion to David that when he goes out for these meetings to the various jurisdictions, that he include the state's attorney and the public defender as a possible participants as well?
So thank you, Mr. Harvey. I appreciate that. I have been doing that on some occasions. I usually leave that up to the discretion of the judges in the particular jurisdiction, but I would say about half the jurisdictions, that is the process that we're doing. And I'll certainly make sure that I do that when I get out to Calvert County.
Yeah, I think I missed you the last time. That's why.
Won't let that happen again.
All right. Well, as far as the rest of the year, our meeting, September 12th is going to be our next meeting at 5:30. That will be a virtual meeting as this
Correct.
was. And then December 5th is our public comments hearing and business meeting that will commence at 5. That'll be in person at the Maryland Judicial Center. And so for those of you that were not here from last year, that is where the public will be invited if they wish to come in and offer comments to the commission. regarding any matters affecting the commission's business? I'll ask anyone, any old business you wish to address? All right, seeing none, any new business? Any announcements? All right, well, seeing none, I'll take a motion to adjourn.
So move.
Judge Avery, yep. Yep.
All right, very well. Well, thank you all very much for, this was a longer one, but I think we had a lot of substantive work tonight. And thank you again to David and the staff for all the tremendous work on not only the report, but all the other matters tonight. All right, thank you all very much. Enjoy the rest of your summer, and I look forward to seeing you in September.
Right on.
Take care, everyone. Summer.
Bye.